And with just the remaining time that we have, I'd love to take a moment to ask our speakers for their key takeaways and some quick final thoughts about today's presentation. Melissa, since we did hear from you first, would you like to start?
Marina, I think the takeaways are how expansive the duty to warn is, and that the way it was created and eventually expanded followed the pace of technology and both technology in terms of what we normally think of as technology, automobiles, computers, but also in terms of how products are sold. And I think an interesting new frontier in this is this online marketplace concept, and where you can sell a product without the product ever actually having come into your warehouse. You never touched it. You don't have any ownership or possession over it at all. But the question is, courts are grappling now with whether or not you have a liability, whether you derived any benefit from having the marketplace, and frankly, just because you're in the best position if the actual seller of the product is not solvent or does not have the deeper pockets, you could still have liability. So I think technology continues to expand. Artificial intelligence, self-driving cars. We're going to see an interesting further expansion, and I think reliance upon the consumer. Normally, you're going to be considered to owe the duty because someone should bear the cost of injuries.
Thank you very much, Melissa. Bruce, some final key thoughts.
Whether you're the plaintiff or the defendant in these cases, you need to try to simplify break down the case. We talked a lot about causation, even though many who practice in this field would say causation is, not even required anymore. I would I would admonish defendants to continue to use it, because it's going to be a requirement of the plaintiff to prove, and there are ways to show that the product itself was not the cause of the injury claim. So that would be my one point to leave everyone with.
Perfect. Thank you very much, Bruce. And Marina.
Sure. And I know I've said it throughout my presentation, but I really don't think you can overstate the importance of being prepared. It's a complicated group of substances, which makes for complex regulations and challenging litigation. So keeping abreast of the legislation that's being considered, and certainly of those regulations that have already come down, will avoid that dreaded element of surprise. Taking the time now to see where the gaps in your corporate knowledge lie around the use of these chemicals, whether in operations, in your products, as part of your disposal practices, or in your purchases, is half the battle. Once you know those vulnerabilities, they can be planned for, addressed, or mitigated before litigation or before a regulator is requiring that information. Thank you.